A very good afternoon. Today, I will present my analysis on how technological transformation, particularly artificial intelligence, which is AI, blockchain, and national digital control policies, affects international maritime law, specifically under the Hamburg Rules. To start our analysis today, I will first explain a few information regarding the Hamburg Rules, which is the Hamburg Rules are a set of international regulation which governing the liability and responsibilities both carriers and also shippers within the sea transport. They were adopted in 1978 and became prominent in 1992 as a modern alternative to earlier maritime convention. So, what are the purpose of the Hamburg Rules? Their main purpose is to balance responsibilities between carriers and cargo owners, while also ensuring goods are transported safely and efficiently across international trade routes. Moving on to the next part of the analysis, I'll be talking about evolution of the Hamburg Rules. So, originally, the Hamburg Rules were designed in a paper-based shipping environment, which was built around physical bills of lading. And over time, the global trade have shifted from paper documentation to an electronic data interchange, which is EDI, and now to blockchain-based system. Currently, modern technologies now allow containers to be tracked through GPS, IoT sensors, and also automated platforms that can transfer electronic bills of lading once delivery conditions are met within the time. Because the rules focus on data rather than paper form, they will remain adaptable to digital documentation system. These include, for example, blockchain ledgers, which can provide immutable shipping records that will improve the transparency and also reduce fraud risk. This also demonstrates that although drafted decades ago, the Hamburg Rules can still function in technologically advanced logistic environment. Alright, moving on to our next discussion, which is about tax sovereignty. So, tax sovereignty refers to a state's ability to control its digital infrastructure, including data storage, software system, and technological standards, so that it is not dependent on any foreign technology. While this strengthens national security and regulatory oversight, it have conflicts with international legal frameworks that rely on cross-border cooperation and uniform standards. One major example is data-localization laws. These laws require digital data to be stored within national borders. Such restrictions directly contradict with international conventions that assume free global data flows. As more countries implement national digital rules, global shipping law risks fragmentation instead of harmonization. For the next part, I'll be talking about the Article 22 versus modern digital arbitration. So, within Article 22 of the Hamburg Rules that governs arbitration and dispute resolution, it allows claimants flexibility to choose arbitration location to ensure fairness and also neutrality. However, strict national data laws can indirectly restrict this freedom. If a shipping records or blockchain data are legally confined to one country, A foreign arbitration tribunals may not be able to access necessary evidence. This means arbitration location may still exist legally but also become impractical or impossible in reality. Another issue concerns whether digital arbitration agreements are legally valid. So, under international standards, arbitration agreements must be in writing, and also it must be clearly related to a legal relationship. For instance, a smart contract code or not understandable to humans. Courts often apply the principle of substance over form, meaning unreadable code may not qualify as a valid written agreement. Moving on to the next part, which is about jurisdictional conflicts in digital arbitration. So, a fragmented globalization increases the risk of jurisdictional clashes. National courts may refuse to recognize foreign arbitration awards if the arbitration process violates the local laws or public policy. This, in fact, becomes especially relevant when automated smart contract system execute decision without human oversight. So, courts may consider such outcomes unfair or also lacking due process. Additionally, an automated arbitration platforms always prioritize speed, but legal fairness requires interpretation, evidence review, and also reasoning. The rigid nature of code can conflict with the flexible reasoning required in the legal arbitration. Moving on to the next part, I will talk about the carrier liability and also AI decision. So, according to Article 5 of the Hamburg Rules, it requires carriers to prove they took all reasonable measures to avoid any cargo loss or cargo delay. So basically, an AI systems can predict risks such as weather disruption, route congestion, and also mechanical failure. If such predictive tools exist but are ignored, carriers may fail to meet their legal duty of care. However, problems will arise when AI itself determines liability. For example, if a system acts as a black box without explaining its reasoning, the carrier may not truly have the opportunity to defend themselves. This raises due process concerns because legal decisions require transparency and also an explanation, not just an automated outcomes. During my research, I found a relevant case study, a real case that illustrating these issues that involve Payword Limited, an operator of crypto platform, and also a customer named Check-in. So, the customer agreed to an online arbitration clause that requires dispute to be resolved under the foreign law. The arbitrator ruled against him, but when the company tried to enforce the award in England, the High Court refused. The court decided enforcement will violate UK public policy because the arbitration failed to consider mandatory domestic laws. This case shows that even valid digital arbitration agreements may be rejected if they have any conflict with the national legal protection. It also proved that global digital dispute systems cannot override national sovereignty. So, in terms of evaluation and legal implication, this case demonstrates that the Hamburg rules are not fully resistant to the modern digital protectionism, and the national courts can override the international arbitration decision if domestic law is violated. Not only that, digital transport documents can improve the transparency and fairness, but they also risk unfairness if users accept hidden terms without understanding them. Therefore, the technology can enhance operational efficiency while simultaneously weakening legal protections if not regulated carefully. Alright, to conclude my analysis for today, in conclusion, the Hamburg rules still remain relevant in this current modern shipping day, but they also face serious challenges from technological transformation and also national digital policy. So for them to remain effective, international maritime law will likely need a unified digital standards that covering electronic evidence, blockchain contracts, and also automated arbitration. Without such modernization, national tax sovereignty laws may gradually limit the effectiveness of Article 22, and it will also reduce the practical value of the international dispute resolution. Thank you for lending your ear and listening to my analysis. If you have any questions, please leave it down in the comment section.